President, please be seated. The court is now back in session. We now move to the session that is questions by the chamber. And I'd like to inquire with the judges of the bench if you wish to put the questions.
Just one remark that I appreciate that the question that was asked to the parties and especially to the OCP may be specific, and even the parties who have intimate knowledge of the case may not be able to cite to the trial record of, from the top of their heads. So I'd be happy to wait until tomorrow for the specifics, and we will make time for the parties to relate to this question, and we will welcome if the OCP would want to indicate which murders it considers proven to the beyond a reasonable doubt standard, if any.
I'm not sure if people are waiting for us to respond. We understood that you gave us time until tomorrow. We'll take advantage of that to be a more thorough list of going through the judgment. Obviously, the murders at Tulpa Ture, we clearly feel proved beyond a reasonable doubt, and we can indicate individual murders during the first and second forced transfer that we believe were proved beyond a reasonable doubt.
President, since we do not wish to put questions to the parties now, and it is deferred to tomorrow's session, we now move on to the fourth thematic session. That is the grounds of appeal related to the accused individual criminal responsibility. And I noticed the defense counsel for Kirsten is on her feet. You may proceed.
Yes, Mr. President. I'd like to avail myself of the fact that the chamber doesn't have any additional questions apart from those we have to respond to tomorrow. I'd like to know whether I can avail myself of this opportunity to provide some specific information. Since the prosecutor talked of the expert Philip Short, and yesterday I said things relying on what I could remember, and I would like to give some more precise information to the chamber to complete my submissions. Perhaps with regard to the issue of characterization, I will deal with that under the theme of responsibility, because that appears to be the theme in which I can treat those issues, and I'll therefore like to give references of statements I relied on, if you would agree with me.
Yes, you can proceed.
Je vous remercie, Monsieur le Président.
Thank you, Mr. President. With regard to what I said concerning Mr. Philip Short, the expert, and the various statements he made regarding whether or not the army was unified or not, I have many authorities that I used in my statement. There's the first quotation, document E295/6/4. We refer to in our closing arguments because it supports our brief, and I argue that they didn't take into account exculpatory evidence. There's the hearing of the 7th of May 2013 by Philip Short, document E1/190.1 at about 13:59 and 35 seconds. And this is what he says with regard to the evacuation of Phnom Penh. It is important since it is within the scope of case 002/01. All descriptions of the evacuations of Phnom Penh and other authorities are concordant in saying that the different zones had quite some latitude with regard to the implementation of the evacuation. Soldiers from the East Zone, for instance, tended to be more flexible than those from the Southwest who were under TAMOC. That was a scheme that was applied throughout the regime, depending on zones, policies, and subordinate cadres. Things change from one place to the other. Same applies to chiefs of villages and cooperatives. There was a large variety. Another quotation by Mr. Short, hearing of the 9th of May 2013, document E1/192.2 at 15 hours 45 and 46 seconds, and he explains the movements of the Khmer Rouge, and this is what he states. He is referring to the period from 1970 to 70. From 1960 to 1970, I beg your pardon. Let me quote him in its entirety. In fact, since the very beginning of the guerrilla in 1968 and in early 1970, it was even more difficult to impose any harmony because of the problems and difficulties they face in communication. As of 1973-1974, communications improved, and it became more easy for the center to align itself with this. But the front line could communicate with chiefs of zones, and that remained the case after April 1975 and throughout the Democratic Kampuchea period. There were considerable variations and many difficulties in harmonizing policies nationwide. Free translation. On the 6th of May 2013, also in response to Judge Cartwright, and it's somewhere before 11 hours, 12 and 15 seconds, document E1/198.1. This is what is stated. Once more, one of the characteristics of the regime was that the treatment reserved to people was not absolutely uniform. It depended on the zones, and sometimes the lower units, it depended on the cadres who were responsible. And on the 9th of May 2013, sorry, I have to move back and forth in my reference of transcript, E1/1/193.1, somewhere around 9:48, 45 seconds. He is comparing the situation with other communists, and he says, I believe that we can say that Democratic Kampuchea is exceptional in many regards, and that is one of its aspects. There was a certain degree of indiscipline that you wouldn't find in what I'll call orthodox Marxist-Leninist countries, end of quote, free translation. And lastly, at the hearing of the 8th of May 2013, document E1/191.1, somewhere around 9:49 and 41 seconds, and he's answering a question put to him by the international co-prosecutor, and this is what he states. And this is the particular point I referred to when I was talking about the unification of the army. This is what he states. One of the problems that Pol Pot faced was that he never truly succeeded in reuniting the armed forces that remained under the control of various warlords, the most important being Kekpok, Sopim in the east, and Tamok, end of quotes. This is what I was referring to when I explained that those some of the criticisms were leveled against the judgment when it talked about a monolithic vision of the movement. This doesn't tally with what this expert himself had told the chamber. And perhaps to say something that ties in with what as the co-prosecutor said regarding jurisprudence and the absence of a nexus, to explain what I said a while ago. When I spoke to the chamber a while ago, I said we were being blamed for talking of the treaty when we talked of the Statute of Rome, because the co-prosecutors themselves made reference to this convention on the fact that war crimes and crimes against humanity were time-barred in 1968, because this convention should be taken into account. This is a convention that was signed of the 134 members of the United Nations at the time. Only 18 countries ratified it, and it is important to bear this in mind, the fact that we are saying that you cannot use such jurisprudence as an example to say that it was part of customary international law at the time. Why? Because the International Court of Justice, in the case of the Continental Shelf case in 1969, explains that for a conventional rule to become a rule in customary international law, a number of requirements have to be met, and it is page 43, paragraph 73 of that decision, and it states the following: as regards other material that are generally taken into account as being necessary for a conventional rule to be considered as a general rule of international law, it is possible that even though a long period may not have elapsed, a very broad-based participation must obtain insofar as it concerns the states that are concerned. So a very large, broad-based and representative basis must obtain, and the jurisprudence cited by the prosecutor was only ratified by 18 out of 134 states of the United Nations at the time. It is not a broad-based representative corpus of states as such, so we cannot consider that it was part of international customary law at the time, because we shouldn't forget the essential point, that is, was such law accessible and foreseeable by the accused, including Mr. Kiel Sampan, bearing in mind the fact that there was a doubt not only in the application of the text, which should benefit the accused, so there's a problem of foreseeability and credibility, which has not been resolved.
Monsieur le Président,
Mr. President, may I avail myself of the time you have given me to proceed to talk about the responsibility, unless there are other questions that you may want me to address.
Defense Counsel, could you advise the chamber how many more minutes you anticipate?
Pardon, excusez-moi, monsieur.
Court's indulgence. It was my fault, Mr. President. I had omitted to say that before the theme of responsibility is dealt with, we have the report of the rapporteurs that has to be presented. I'll allow you to do so then.
I'd like now to hand the floor to the co-rapporteurs for the fourth thematic session on grounds of appeal related to the accused's individual criminal responsibility. Judge, Mr. President, allow me to read the co-rapporteur's report for session on grounds of appeal related to the accused's individual criminal responsibility. The trial chamber found Nunchi and Kiel Sampon to be individually criminally responsible through their participation in a joint criminal enterprise in its basic form, also known as JCE-1. For some of the crimes committed during population movements phases 1 and 2, as well as at Tulpu Chre. Individual criminal responsibility through JCE was affirmed in respect of the crimes of murder, persecution on political grounds, and other inhumane acts encompassing forced transfers and attacks against human dignity in connection with Population Movement Phase 1, persecution on political grounds and other inhumane acts encompassing forced transfer and attacks against human dignity in connection with Population Movement Phase 2, and murder and extermination in connection with the events at Tulpu Chirei. In addition, the trial chamber found that the accused had planned, instigated, and aided and abetted, and that Nunchi had also ordered all crimes charged in connection with the True Population Movements and the Tulpu Chirei. Those crimes include, in addition to the crimes we have just mentioned, extermination, persecution on political grounds, and other inhumane acts encompassing forced disappearance. The trial chamber, however, entered convictions based on these forms of liability only to the extent that the crimes were not encompassed by the JCE. Similarly, even though the trial chamber found that Nunchi, but not Kir Sampon, was criminally responsible for all crimes based on the notion of superior responsibility, it did not enter a conviction on that basis, because he was directly responsible for these crimes through his participation in the JCE. Further, whilst the trial chamber found both the accused criminally responsible for murder in connection with Phase 1 of the Population Movement and at Tulpu Chirei, it held that extermination as the more specific offense subsumes murder and therefore entered a conviction only for extermination encompassing murder. Nunchi and Kir Sampon raised various grounds of appeal in relation to all modes of liability considered by the chamber, which we shall briefly summarize. A. Grounds of appeal relating to joint criminal enterprise. The trial chamber determined that liability under JCE in its basic form requires that a plurality of individuals share a common purpose, which amounts to or involves the commission of crimes, and that the accused person must participate in the common purpose by making a significant but not necessarily indispensable contribution to its implementation. The trial chamber noted that participants in a JCE can incur liability for crimes committed by direct perpetrators who were not JCE members, provided that it has been established that the crimes can be imputed to at least one JCE participant, and that this participant, when using a direct perpetrator, acted to further the common purpose. Further, the trial chamber found that liability under the notion of JCE in its basic form requires that the accused must intend to participate in the common purpose, and this intent must be shared with the other JCE participants. The trial chamber found that at the latest, by June 1974 until December 1977, there was a plurality of persons who shared a common purpose to implement a rapid socialist revolution through a great leap forward and defend the party against the internal and external enemies by whatever means necessary. The trial chamber found that while this common purpose was not criminal in itself, according to the charges against the Nunchi and Kir Sampon, the participants implemented the common purpose through the population movement policy and targeting policy which resulted in and/or involved crimes, including forced transfers, murders, attacks against human dignity, and political persecution. The trial chamber found that the crimes committed during population movements phases 1 and 2 can be imputed to participants in the JCE who, when using a direct perpetrator, acted to further the common purpose. The trial chamber concluded further that there was a policy to target former Khmer Republic officials which involved the murder and extermination of former Khmer Republic officials at Tulpu Chey, and that those crimes could be imputed to at least Ruh Nhim, Secretary of the Northwest Zone and a participant in the JCE. In addition, the trial chamber noted that crimes covered by case 002/01 could be directly imputed to Nuon Chea and Khieu Samphan, given the trial chamber's findings that they had planned, instigated, as well as aided and abetted, and in the case of Nuon Chea, ordered the crimes. Regarding Nuon Chea's contribution to the implementation of the common purpose, the trial chamber found that he was not only involved in the initial development of democratic Cambodia policies, but was also actively involved in their continuing implementation throughout the period relevant to case 002/01. The trial chamber distinguished between two types of contributions. First, Nuon Chea's involvement in the planning of the common purpose, and second, his role in disseminating and implementing the common purpose through propaganda, education, and public training. As to Nuon Chea's intent, the trial chamber recalled his role in formulating the policies of the CPK and his membership in the committees that decided on the population movements. The trial chamber found that he was also a strong proponent of waging class struggle, and that his role in trainings and propaganda activities showed that he intended to further the implementation of the common purpose. The trial chamber also found that he shared the intent with the other participants in the JCE to commit the crimes at issue in case 002/01, including discriminatory intent required for the crime of persecution on political grounds. With regard to Khieu Samphan, the trial chamber found that he contributed to the implementation of the common purpose in 5 ways. First, he attended meetings of the standing and central committees and of party congresses, where the common purpose and policies were planned and developed. Second, he attended meetings and sessions where lower cadres of the Khmer Rouge were informed about the common purpose and policies. Third, he was involved in economic matters of the Democratic Cambodia regime, notably in the field of trade, export, import, and commerce. Fourth, he made public statements in support of the common purpose and policies, encouraging the Khmer Rouge cadres and the population at large to adhere to the party line. And fifth, he liaised with Norodom Sihanouk and maintained diplomatic contacts with external actors with a view to garnering foreign support for democratic Cambodia. On appeal, Nuon Chea and Khieu Samphan raised numerous arguments against the trial chamber's approach and findings on JCE liability. These arguments may be grouped as follows. The first group of arguments relate to the legal foundation of the notion of JCE liability. Nuon Chea in particular submits that, at the time relevant to the charges, Liability for joint perpetration of a crime was narrower and required a contribution to the actual crimes. The second group of arguments relates to the common purpose. Nunchi and Keo Sampon argue that the trial chamber erred because the common purpose it identified, the implementation of a rapid socialist revolution, was not criminal in itself. They also aver that the trial chamber erred when it found that the CPK had adopted policies of population movements and targeting Khmer Republic officials and soldiers. Moreover, they submit that the trial chamber erred by assessing whether the implementation of the policies involved and or resulted in the commission of crimes, arguing that this unjustifiably lowered the requirements for liability under JCE 1. The third ground of arguments concerns the contribution that, according to the trial chamber, Nunchi and Keo Sampon made to the implementation of the common purpose. These arguments include challenges to the trial chamber's specific findings on their role and powers within the CPK and the Democratic Cambodia regime. The fourth group of arguments relates to Nunchi's and Keo Sampon's intent, challenging the trial chamber's approach and findings in this regard. B. Grounds of appeal related to other modes of liability. Nunchi and Keo Sampon also argued that the trial chamber's findings as to their liability for planning, instigating, aiding and abetting, and, in respect of Nunchi only, ordering and superior responsibility, are tainted by numerous errors of fact and law. In relation to his liability for ordering, Nunchi argues in particular that the actual serious of ordering was not established because the decision to evacuate Phnom Penh and to move the population between rural areas happened at meetings of the standing and or central committees. Any decisions taken at those meetings were implemented by the zone secretaries, who did not act upon the orders of Nunchi. The same applies in Nunchi's submission to the events at Tulpu Chire. Regarding their liability for planning, the accused argued that the trial chamber incorrectly defined the actus reus and that the mere taking of decisions is not equivalent to planning. Regarding their liability for instigating and aiding and abetting the crimes in question, Nunchi and Keo Sampon allege primarily factual errors in the trial chamber's findings, or submit that the activities identified by the trial chamber do not constitute the actus reus of those forms of liability. Further, in relation to all of these forms of liability, the accused argued that the trial chamber applied an incorrect standard in respect of the mens rea, which was not covered by customary international law as it stood at the time the crimes were committed. In addition, Nunchi and Keo Sampon raised arguments that relate in their submission to the trial chamber's findings on liability both under JCE and under the other forms of liability. Notably, they raised arguments alleging errors in respect of the trial chamber's findings as to the structure of the CPK and the modes of communication. Furthermore, Keo Sampon submits that the trial chamber incorrectly relied on omissions as opposed to positive conduct when finding that he made a contribution to the implementation of the common purpose or aided and abetted the crimes in question. This concludes our report on the grounds of appeal relevant to this session of the appeal hearing. Thank you. President, thank you. It is now appropriate time for our lunch break. And we will resume this afternoon at 1:30 p.m. Security personnel, you are instructed to take the accused to the waiting room and have them return to attend the proceedings before 1:30 this afternoon. The court is now in recess for lunch.